He spent 17 years locked in a psychiatric facility. His crime? He was never convicted of one. The charges were minor. The wait was a life sentence. And this legal loophole still traps thousands today. Thean Jackson was a 27-year-old deaf man who could not read, write, or communicate effectively. In 1968, he was accused of stealing $9. The charge was minor theft. But Jackson could not understand the proceedings against him. Doctors declared him incompetent to stand trial. Under Indiana law at the time, this meant commitment to a psychiatric facility until he became competent. But here is what nobody told Thean Jackson. His mental condition was permanent. He would never become competent. The maximum sentence for his alleged crime was 60 days. Instead, he faced indefinite detention. And this was completely legal. The question nobody asked was simple. How long can you hold someone who cannot be tried? The answer would take 17 years to determine. To understand how this happened, you need to know what competency actually means. It is not the same as insanity. Insanity asks whether you knew right from wrong when you committed the crime. Competency asks something different. Can you understand the charges against you right now? Can you assist your attorney? Can you comprehend court proceedings? The standard comes from a 1960 Supreme Court case. A defendant must have sufficient present ability to consult with their lawyer and a rational understanding of the proceedings. If you fail this test, the trial stops. You cannot be convicted. You cannot be acquitted. You exist in legal limbo. And that like button helps more than you know if this is opening your eyes. Across America, thousands of defendants entered this limbo every year. Most were restored to competency within months. But what about those who could never be restored? Now imagine you are Thean Jackson. You wake up every day in the same facility. You do not understand why you are there. You cannot ask questions because nobody speaks your language. Years pass. The seasons change outside your window. But nothing changes for you. And this is where I need you to pay attention. Jackson was not the only one. Across the country, defendants deemed permanently incompetent were being held indefinitely. Some for shoplifting. Some for trespassing. Some for crimes that carried sentences of mere weeks. They sat in psychiatric facilities for years. Even decades. Not because they were dangerous. Not because they were receiving treatment. But because the law had no mechanism to release them. The system designed to protect them had become their cage. And nobody was looking for the key. Jackson's case finally reached the United States Supreme Court in 1972. His attorneys argued something that should have been obvious. Holding a person indefinitely because they cannot be tried violates the Constitution. The state of Indiana disagreed. They claimed the commitment protected both society and the defendant. But here is what the evidence showed. Jackson was not receiving meaningful treatment. His deafness could not be cured. His lack of education could not be remedied in months. The maximum sentence he faced was 60 days in county jail. He had already served 3.5 years. 3.5 years for allegedly stealing $9. The justices had to answer a fundamental question. Does the Constitution allow indefinite imprisonment of the unconvicted? Think about that. He was never found guilty. He was never found innocent. He simply could not have a trial. But that is not even the most disturbing part. The Supreme Court ruled unanimously in Jackson's favor. Every single justice agreed. The decision stated that indefinite commitment of an incompetent defendant violates the Equal Protection Clause. You cannot hold someone longer than the maximum sentence they would receive if convicted. The ruling should have freed thousands. It should have reformed the system overnight. But watch what actually happened. States were given no clear timeline to comply. Enforcement mechanisms did not exist. And facilities had no incentive to release patients. 30 years after Jackson, studies found defendants still waiting years for competency restoration. In 2005, one survey found the average wait for evaluation alone exceeded 8 months. Subscribe now because what happened next will change how you see the justice system. The Supreme Court spoke. But the system barely listened. Today approximately 60,000 competency evaluations are ordered annually in the United States. That number has grown 300% since 1980. And the crisis has only worsened. Forensic psychiatric beds are scarce. Wait times stretch for months. Defendants sit in jail cells waiting for evaluations. Not hospital beds. Jail cells. Many receive no mental health treatment while waiting. Their conditions deteriorate. When they finally receive evaluations, many are found incompetent. Then they wait again. For treatment beds. For restoration programs. For someone to remember they exist. Drop your prediction in the comments. Do you think this system has improved since Jackson? The answer might surprise you. Some states have made progress. Others have moved backward. And the Constitution that should protect these defendants often provides no remedy at all. Here is the truth nobody wants to admit. The competency system was never designed for the current mental health crisis. It assumes treatment works quickly. It assumes beds are available. It assumes society prioritizes mental health. None of these assumptions hold today. The Jackson decision established a ceiling. You cannot hold someone indefinitely. But it created no floor. States can still hold defendants for months or years as long as they claim treatment is ongoing. The result is a shadow justice system. People accused of crimes but never convicted. Held in facilities they cannot leave. Receiving treatment that may not help. And watching their lives disappear one evaluation at a time. Thean Jackson was eventually released. But the system that trapped him still exists. The loophole has been narrowed. It has never been closed. And thousands remain caught in its grip right now. Some states have implemented reform. Caps on restoration treatment periods. Outpatient competency programs. Charges dismissed after reasonable attempts at restoration fail. But implementation remains inconsistent. Funding remains inadequate. And the fundamental tension remains unresolved. How do we balance public safety against individual liberty for those who cannot participate in their own defense? There are no easy answers. But there are better questions. Should we charge people we can never try? Should jails serve as mental health holding facilities? Should the accusation